I think that you'll find this topic especially relevant, cutting-edge stuff. We're talking about evidence as it relates especially in the technology context. Both of our speakers today are from Texas, from our Texas office, but they are lead litigators, which means they've done a lot of litigation and they teach litigation. They were rising stars, et cetera, voted litigators by their peers. But most importantly, they've dealt with these specific issues a lot, and much of this is becoming federalized. So we'll talk about the federal piece, but to the extent they're talking about the Missouri piece, they will have researched the issue on Missouri's rulings in particular. But the trends in this area, which they'll discuss, seems to be to federalize many of these issues. So this is cutting-edge information on those questions that you probably struggle with every day that you didn't think you'd be thinking about 5 years ago. So Raul Sandoval is a lead litigator. He's in our Austin office. And then Maribel, right? Did I say that correctly? Yes. Maribel Cruz, and she's also a lead litigator, and she's in our San Antonio office. Let's welcome them to take us to our lunch break.
Good morning, everyone. Not only are you going to find out a lot of helpful information in the cutting-edge information that Mr. Cordell just mentioned, but the best part is you get to have lunch right after. So I guess firstly, very basic concept, but still very important. Read and understand the rules. I can't stress enough that you just get a good grasp of your rules of evidence, read through them, pick up what you can. You probably won't learn it right off the bat, but the more you read through them, the more you understand them, the more helpful it's going to be. Now, of course, in the family law context, there are some big hitters that you'll want to have a really strong grasp of that come up often. Of course, you have your hearsay, your entry of records. So those rules you certainly want to have a really strong grasp of. But just in general, read and understand the rules. Because if you want to get in the courtroom, you want to be able to spot the infraction by opposing counsel, and you want to be able to explain that to the judge. You'll have some judges who won't just sustain an objection just by raising the objection. You'll have to explain why it is you're objecting. So just make sure you have a really strong grasp of the rules. This presentation is not necessarily going to go into the rules of evidence per se, but starting with a very basic concept is going to be helpful to in your practice of family law. So firstly, shared iCloud accounts. Again, this area is developing, and so the law related to the areas is still working itself out as far as what's done with information gathered from shared iCloud accounts. And so firstly, how do we retrieve this sort of information? So first of all, you certainly want to woodshed your client. Make sure you gather those facts early and often, your initial consultation, your initial meeting with your client. So you certainly want to discuss that early and often in your case. Additionally, discovery requests, requests for production, depositions of the opposing party. You can certainly request to depose the party and request that they produce the text messages, emails, etc., from the iCloud account. Additionally, subpoenas are another way to retrieve this sort of information. Now, again, this area of law is certainly something that is developing. We need to keep in mind the pitfalls. It's not something that we can take for granted nowadays with the federal and Missouri wiretap acts to keep in mind. So, for instance, the Missouri Wiretap Act, we need to keep in mind that there's penalties related to interception of this information, interception of text messages, interception of emails. And so the definition by the Missouri Wiretap Act indicates that To intercept is defined the oral acquisition of the contents of any wire communication through the use of any electronic or mechanical device, including but not limited to interception by one spouse of another spouse. So I'm sure we run across often where a client brings in helpful text messages or helpful emails, and we really need to be careful as far as how this information was retrieved. Was it illegally intercepted, or was it something that the parties exchanged with each other? So we really need to vet our clients early and often as far as how this information was gathered. Because now when we're dealing with shared iCloud accounts, we need to keep in mind whether there was authorization of this information, or and we'll talk a little bit more about ability to gather this information or retrieve this information versus authorization to retrieve this information. Now, under the Missouri and Federal Wiretap Act, evidence is inadmissible if it's intercepted. So that's one important factor to consider. It's inadmissible. More importantly, though, the Federal Wiretap Act also makes the attorney personally liable. So it doesn't matter if you didn't know, if you had reason to know that this information or this text message, this email was illegally intercepted, you could be personally liable for that as well. There's no attorney immunity, so we really need to vet our clients in a very detailed fashion to make sure that it wasn't illegally intercepted, because again, we can be personally held liable. And there's civil and criminal penalties to keep in mind for the Federal Wiretap Act. For the Missouri Wiretap Act, only civil causes of action are available. Yes?
At what point do you become liable? I mean, you say you're liable, and this happens like when the client presents it to you, you're suddenly liable, or if you use it at trial?
Okay, so the question was, at what point do you become liable if you gather this information and it turns out that it was illegally obtained? I'm glad you asked that question. It's the use and disclosure as it's statutorily defined by the Federal Wiretap Act. And so the use and disclosure would be, for instance, client gives you text message. You don't fully vet your client as far as how it was retrieved. You take it for granted. You go to court. You use it, whether you ask a question about it, because even the hinting of that information from that text message, if you even hint at it, that can be personally liable. Or if you introduce the text message into evidence, that is use and disclosure, and that would subject you to civil and criminal liability as well. Was that?
Yes, that was really helpful. I had a case recently where the client had his wife's cell phone. The messages were popping up. He didn't hack into an account. And there was something on there that hinted at a death threat to him. Like it sounded like she was trying to hire someone to kill him.
Right.
I'm like, what do I do with that?
Well, and so the first question is how he retrieved the cell phone to retrieve these messages. If he wasn't authorized to do it, then you don't want to put yourself in that situation and using this information. The Federal Wiretap Act may subject you to that personal and civil liability. So this is not something that has come up often, especially now that more of this technology is coming into play. But now that we have more things like shared iCloud accounts or GPS, more technology, we really need to focus more on the Federal and Missouri Wiretap Act because again, the liability is not worth it. Now, in addition to the Federal and Missouri Wiretap Act, we need to keep in mind the Stored Communications Act. So the Federal and Missouri Wiretap Act deal with interception of oral, wire, or electronic communication. And the Stored Communications Act is actually storage of that information. Now, electronic storage is the threshold for the Stored Communications Act. So, for instance, the Stored Communications Act is actually what the shared iCloud account is probably gonna fall under, more so than the federal and Missouri Wiretap Act. However, you still want to determine whether the text messages or emails were illegally intercepted. But the Stored Communications Act makes it an offense to intentionally access without authorization a facility through which an electronic communication service is provided, or intentionally exceeds an authorization to access that facility, and thereby obtains that information from that electronic storage system. So we're talking about a shared iCloud account in this context. And so courts have struggled to determine what that temporary intermediate storage definition is, and how that plays, or how to apply it. Now, the Eighth Circuit actually has indicated that in the Eighth Circuit in Ansaldúa versus any ambulance and fire protection, Eighth Circuit 2015 case, the court held that the ability to access email is not the same as authorization. In this case, the violating party had retrieved the password at a certain point to an email, and the authorization was simply to access the email and send out resumes. Well, a year later, when there was a lawsuit present, this person still had that password and accessed the email, retrieved the email, and used it in his case. Well, he violated the Stored Communications Act because just because you have the ability to do it doesn't give you that authorization. So even if, let's say in the family law context, if husband had the authorization at one point, she gave me the password to access her phone in this particular situation and for this particular authorization, that doesn't give him the authorization to later use it, especially in a family lawsuit. So if that does occur, again, you need to make sure that you talk to your clients about how this information was retrieved, because not only do you want to explain the penalties associated with your client, but the penalties associated with yourself. Now, the Stored Communications Act doesn't subject an attorney to civil liability or personal liability. However, the Wiretap Acts do. Now, let's say we've fully vetted our clients, we've properly retrieved the text messages or the emails from these accounts. He had proper authorization to access these shared iCloud accounts. So if there are photos to Paramore, if there are text messages to Paramore, and wife or husband just didn't really care that, or didn't remember that, yeah, we both knew that this sort of information was on the iCloud, great, we can use it, we can gather it. And as far as using it in court, make sure you actually use the exhibit. So identify the witness who's best able to prove up these photos or text messages. So for instance, if it's a photo of wife sending to Paramore, a nude photo in family law context in particular, you would obviously use the spouse who sent that photo to get that exhibit, that piece of evidence into evidence. And so make sure you lay the proper foundation, identify, hand the witness the piece of evidence, identify it, it's a true and accurate copy, move to enter it into evidence. It's very simple. It doesn't need to, you don't need to dance around it. You don't want to waste your time. Just make sure you lay your proper foundation. Now, keep in mind, some judges prefer that you have your exhibits pre-marked, so make sure you have your exhibit stickers if you have to do that, or you can walk up to the court reporter and have the court reporter mark your exhibit before you hand it to your witness. Keep in mind that you can lead the witness when you walk them through your foundation or predicate, and make sure you actually use the piece of evidence. If you're not going to use it during your presentation of your case, then you probably don't need to enter that piece of evidence. So make sure you're using it. What I like to do is I like to make at least 4 copies, have one for yourself, one for the opposing side, one for the witness, and I like to just hand it to the judge before I even walk through a foundation or predicate, and I guarantee you, judge is going to pick it up, look at it, so before the other side even gets to object, the judge already has that information. So that's a tip on if you have a questionable piece of evidence, the judge will take a look at it in all likelihood if you put that copy for him or her beforehand. Now, keeping such information out at trial, obviously objections, you can object to lack of foundation, lack of authentication, objection to hearsay, or if you can object that the certain piece of evidence wasn't introduced through discovery. A lot of attorneys forget that, but that comes with thorough preparation. You need to make sure that you have your requests, you have what was produced. Hopefully they've Bates labeled. If they haven't, make sure you outline what was produced, what wasn't produced, so that you can identify in court if they're trying to sneak something in at trial that they haven't previously produced that was properly requested. So that's still an appropriate objection at trial as well. And then, of course, much like we walked through the Federal and Wiretap Act, Federal and Missouri Wiretap Act, Stored Communications Act, those are other ways to object and keep certain information or pieces of evidence out at trial. If it's something that you question whether they properly retrieved that piece of evidence or not, take the witness on voir dire. Ask the judge, Your Honor, may I take the witness on voir dire, and vet the witness as far as how that information was retrieved so that you can prove up whether it was illegally obtained or not. It's certainly appropriate to do that if you're opposing a piece of evidence to take the witness on voir dire. The advocating attorney, make sure you advise your client of his or her Fifth Amendment right before going to court. You don't want to get in a situation where the Federal or Missouri Wiretap Act come into question in court and you haven't advised your client of the pitfalls related to certain pieces of evidence that may be introduced in court. So make sure that you advise them of their Fifth Amendment right. If the retrieval of that information was questionable, they need to know that beforehand, before going into court, and understand the risks, understand their rights.
So I'm going to talk to you a little bit more about consent-based GPS trackers and non-consent-based GPS trackers. I'm going to hang out right here, Raul. Nothing makes a family law attorney more giddy than finding that perfect little bit of evidence against the other side. And in this technology-laden based world, that perfect piece of evidence usually comes in the form of electronic evidence. Nowadays, that's how you're getting all of your bad information either used against you or against the other side. So today, attorneys have to ask their clients specific questions. And those kind of questions include, what type of phone device do you have? Do you have an iPhone? Do you have an Android? What do you do to back up your information? Do you back up to the iCloud? And if you don't know what the iCloud is, most iPhones automatically come backed up to the iCloud. Everything goes up into this imaginary location. All your data, all your telephones, all your text messages, photographs, all of them are uploaded into this system that can be pushed down to any other iCompatible or Apple compatible device, which means that if you've got a child that you have attached your iCloud password to because they have an iPad mini and they play their toys on games on that iPad mini, and you have your username and your password attached to that, well, hello, now they can get all of your text messages too. And if you happen to send that iPad mini with your spouse or your ex or baby mama, baby daddy, they have all of those text messages that you have been sending, along with all of the photographs, immediately at their disposal. The other question that you want to ask your clients is, do you erase your text messages automatically? How often do you erase those text messages? If they're erased, are you dealing with ethical concerns in regards to hiding information, deleting information? Are you going to have a finding that you have automatically withheld information just by virtue of the fact that you have what you've done for years and just deleting your text messages? Do you and your spouse have a Facebook page? Is it locked? Is it open? Who has access to it? Who are your friends? If you have 500 friends on your Facebook page, probably a bad idea, because one of them is going to tell somebody else what's on your Facebook page. You need to know what type of computer you have, what entity it works with, who you work with, how you have your Gmail account set up or your electronic mail set up. Baby monitors. I don't know if you've ever thought about this, but baby monitors can also be used to watch people. And I'm going to talk a little bit about baby monitors. And have you heard of those Nest cameras, security cameras? Husband and wife are living together in the same home for years, and they have security cameras that are mounted on the outside of a door or mounted in a living room, and you never thought anything about it. Well, is that consent to have that already in your home? You both knew about it. You both have passwords. You're shaking your head, but you both had passwords. You both knew about it. So is it consent? Then can you use the information? Can you ethically use that information? But vehicle tracking devices, this is a new one, and this is the kind of one I'm going to talk to you about next. Vehicle tracking devices are really interesting right now because insurance companies are loading these or allowing their customers to use these GPS-based trackers. They are offering discounts in order to, oh, here we go. I'm just going to let you know, this consent-based picture right here, this is the USAA tracker. I understand Allstate has it, and I can't remember State Farm, I don't remember some of the others. But that little black device on the corner, that's the device that gets plugged into your onboard system on your computer, on your vehicle. So vehicle tracking devices seem like they're innocent. You know, they come from the insurance company. The insurance company is offering people discounted rates, 15% off, put my GPS tracker in. They collect data, and they're telling you, hey, customer, we're collecting data. We want to know what your driving habits are. Help us help you. We want to know how you're driving. Well, that's all fine and dandy when you're in a blissful marriage and you don't have to worry about where you're coming and where you're going. But if you have that one spouse that's cheating, uh-oh, now you know everywhere they went. So in this instance, here's what they do. There's an onboard diagnostic port. It gets put into underneath the steering wheel, the steering kind of column. You don't notice it. And once you've had it for that long, and, you know, husband may say, or wife, whoever is the one that ends up with the financial, you know, deductions. They say, hey, I need a deduction. We need to lower our income or our expenses. Let's put this thing in here. And then you forget about it. And it's sitting there and you're driving around with this thing day after day, and it's not important to you. You don't see it. It's not like this big flashy thing. You know, it's not like it lights up or anything. So you ignore it. But it tells you how, where, and when the vehicle is driven. It wirely transmits the data from the vehicle to the insurance company. Even if the vehicle is outside of a cell phone tower location, once it hits a cell phone tower again, it's going to automatically download all of that information, and it's going to be sitting at your fingertips. Now, this is kind of blurry, but once you get signed in on this particular one, this is the USAA one, this is what you're going to see. You're going to see a username and a password gets you into this page. On this page, there is going to be last known locations, driving events, braking, acceleration, overspeed, all of the trips that you've taken along with the routes that you took on a real pretty little map with the stops along the way. It'll tell you the distances driven. It'll tell you the number of trips per day and the times per day that they were taken. This is what the detailed map looks like, and you can see all the little stops that are along the way. So just so you know, I have the same thing in my vehicle. My husband said the same thing. 15% off, let's do it, it's great. First time he does it, he was like a stalker. I stopped to get dinner or lunch with a friend. I'm sitting in the car waiting for my friend to show up. My headlights are on. He sends me a text. Your lights are on. Creepy. So, we as family law lawyers need to be aware of these electronic devices that are on your clients' vehicles. It may have seemed innocent when they were installed, but it's not innocent once you're trying to deal with adultery. Sometimes you're even dealing with family violence in these situations, which leads me to our security cameras. This is the Nest camera. Look at how unassuming it is. It's a pretty little thing you can put on a tabletop. You can barely even notice it. You install it sometimes, like I'm pregnant. I'm thinking, I want a Nest camera because it will show everything my child is doing. I can record it. I'll put it in the room. I'll see everything. It has a night vision. It's amazing. And at the time you put it in, you're not thinking about what's going to happen 5 years from now. So this particular security camera, and a lot of them will have these exact same features to them, it has a live video feed 24/7, which means you can be at work and you can still see what's going on in your home. It's a security camera. You should be able to do that. You want to see somebody breaking into your home? This is how you're going to see it. But this is also how you're going to catch a spouse doing things they shouldn't be doing. And it records. So you can get a username and a password, and it can be uniquely assigned to one individual. Both people don't have to have it, so you can only do it to one. You can do it to both, whatever you want to do, whatever the case may be. It's absolutely fascinating. This one actually came in from one of my cases. It's got like a timeline. And so you see a date and all these little dots where things were recorded. And it was recorded because movement starts it recording. So once it notices that the Nest camera is kind of doing a moving detection, it will start recording. And it stops recording after there's no more movement after a certain period of time. So I'm looking at this thing for my client. I'm picking these days. I saw some things I did not want to see. But then I got to where I needed to be. I got to where the altercation occurred. And it was 4 o'clock in the morning. And the lights were out. I could see every pore on this man's face. I could see every gesture on the woman's face. I could see a sleeping child hanging over the shoulder of my client at 4 o'clock in the morning, and I could hear everything they were saying, clear as day. So the question is, if they both gave consent to put this thing on their home, they both have access to it, they both have usernames, and they both have passwords, is it admissible? Well, there's no case law on this kind of stuff. Go back to your old case law. And if it's consent-based and you both had equal access to it, why can't you use it? At least until somebody tells you that you can't. You may need to try harder to authenticate it. You're going to have to lay the foundation on how you got it, when it was installed, who has access to it, whose passwords they are, how they recorded it, what was the system to get it off of the recording device. So you're going to really have to train your witnesses on the applicability of the removal of the information on this. This is a video, so it's going to probably be pulled down on a video, an iMovie, or a JPEG or an MPEG or something like that, and they're going to have to understand how they pulled everything off and moved it into a system that will only show the important, pertinent parts. Just so you know, too, these are an application enabled, meaning that you can have an app on your phone, Android or iPhone, and you can click on that little button and you can see immediately what's going on in the home. This is some of the photographs from live kind of video feeds. You can see some of them are night vision. So you're not coming across like Army or anything, military. It's not green. It's actually very well lit. I don't even know how they do it. I'm way not technologically advanced for that. But you can see specific details on what's going on even in the middle of the night. These things are discreet. They're not very big. They are noise canceling, meaning as long as the voice is there and is talking, you're going to be able to hear every single word. You're going to be able to see a parent interact with their children, so you can use it for your evidence. Mama's sitting there saying, Dad is the most horrible person in the world. He's always angry. He beats our child. He hits our child. Horrible, horrible, horrible. And you take these Nest cameras or these security cameras and you show loving, caring, homework, helping spouses. And it's all there. So it works for you just as much as it works against you. It will show arguments. Two people are arguing. They get to the courthouse. He said this, she said this. Oh, really? I got the video right here. Let's see what they did. Physical violence can be proven on this easy. And then if there's no physical altercations, that can be verified as well. All right, moving on. Next one, Find My Friends. Everybody knows about Find My Friends. It's already installed on most iPhones as it is. It's probably the single most widely used consent-based GPS tracker on the market. It's free to download. It's only installed on Apple devices, but what you do is you request for your friends to follow you. So you're sending out the request. And this is almost like the GPS tracker I showed you earlier with the vehicle one. It will follow your phone instead of your vehicle. It will show the routes. It will show the stops. It won't show the driving history or anything, but it will show the routes that are going back and forth. The thing about this one is that it's consent-based, meaning you're the one who loaded it. You're the one who created it. You allowed everybody else to watch you. The only way you turn it off is to specifically go into the settings and stop either people from watching you or removing yourself from that location or from the Find My Friends app. One of the ways that I've been able to get this information is to actually request for production to turn over your phone. Not just the card. I know, you're looking at me crazy. It's worked like half the time. So sometimes it works, sometimes it's the same thing as doing an inspection of property. It's the same thing as doing an inspection of your computer hard drive. You don't necessarily have to turn it over to the attorney, but you can turn it over to a Geek Squad or somebody like that to download the contents of the phone. And now you have all the GPS tracker information, you have all the text messages, you have everything that is attached to that cell phone. All right, so let's talk a little bit about non-consent trackers. Most of the non-consent GPS trackers don't necessarily come from the other spouse. And I bet you about half the people in this room have some of these already installed in their phone and haven't turned off their location services. Some of these non-consent trackers come installed already in the newest released cell phone devices, Androids and iPhones. They're hidden on almost all devices, and the biggest problem with the use of these trackers include the ethical considerations of using them. Because whereas the other ones, you specifically did something to get to use those. You called your insurance company, you put it on your car. You downloaded it, Find My Friends. You have a secure, you've done these things. The ones that I'm about to talk about now, they're automatically installed on your phone. You didn't ask for this to happen. It's happening behind your back because of marketing purposes for, iPhone, for Android, for Neiman Marcus, whatever it is, they're tracking you. So, the wiretapping laws that Raul told you about will apply to these. So be very, very careful with the use of this kind of information. You're going to need some sort of consent to get them off, maybe they acquiesced. The thing about these particular, the one that I'm about to tell you in a second, is that there is no law out there discussing what happens in this situation, because these are other marketing tools used by the devices that you have in your hand. So your wiretapping holds the attorneys to a higher standard on the use of these. And I was looking on my phone earlier because last week I saw something come down from your Missouri bar where one of your members of the bar was disbarred for a period of time because he used documents and evidence, I think they were emails, that were pulled down without consent in violation of the wiretap laws. And so you have to be very careful how you're using this information. Ensure that you're getting either the passwords or that you're getting it through a request for production through like Geek Squad, like I said, pulling down all those information. This is the only way you're going to be able to get it. Okay, so let's get down to the nitty-gritty. Here's how I'm going to show you how to turn this little booger off. And you're going to see it too, so it's going to creep you out. So if you have an iPhone, and I only know how to do iPhone, I'll give you the website to do Android. Under your settings, so go into your settings, go to privacy, click on privacy, then go to location services. Do y'all see a map yet? You see that map? You see all the places you've been, all the stuff you've done. Are you scared yet? All right, so you're going to go to system services after that. Then you're going to go to frequent locations. Do you see a map or a list? Wah, wah, wah. Go ahead and turn it to off. Click off. And now they can't track you anymore. But I saw your face. Yeah, it's creepy, right? Totally creepy. Here's how you do it on the Android phone. And all of this same stuff is actually on that website. It's the todayshow.com that did it. Did an expose. I freaked out. And then I thought, ooh, this is good for my clients. Woohoo. You want hacked emails? Your hacked emails, right?
Right.
Want it?
Yeah. Thank you.
If you look, there's also an icon on your phone that'll tell you that location services are turned on.
Yeah, in case y'all didn't hear that, there is an icon on your phone that will tell you when your location services are turned off. And I can't see very well in the back, but I see a hand.
Yeah, I wanted to ask you behind this about spousal privilege, the communication privilege that exists in Missouri, and how that affects anything that you're seeing on something that's taping you at home, that's a conversation. And so I'm wondering whether the spousal privilege communication will make that
Well, I guess the answer to the question would be more on whether you're in an adversarial position at that point, and will the courts allow the testimony when you're in an adversarial position. It's my understanding that the spousal privilege will typically apply for issues in regards to criminal conduct, but if the criminal conduct is against the spouse that is claiming it, or the non-spouse, then we've got a problem.
Yeah, and it is there's two kinds of privileges. One has to do with a criminal case, and I'm not going to get into.
Right, but if you're dealing with a protective order,
Yeah.
right.
In a civil case, and one spouse, I think, can stop another spouse from testifying about something.
And here's where I'm going to have to defer to experts that are smarter than I and who are actually practicing in this state to be able to give you the specific information on spousal privileges in Missouri. We have a different sort of code sections and things that are allowed. In Texas, it's allowed. And so I hope that I don't sound like a complete idiot. It's just that I don't think that I am capable of giving you a good answer to that, especially since I haven't researched that particular situation. But I'll see if I can find somebody who can help you out. Thank you.
All right, so now we're into hacked emails. Again, we're dealing with federal Missouri Wiretap Act, Stored Communications Act, and emails we deal with all the time. Now, of course, if it's between spouses, that's probably not going to be something that you should be particularly worried about, because if it's from your client to the opposing side, or opposing side to your client, I mean, those are definitely admissible. So we're probably talking about emails from spouse to another party. So, for instance, maybe paramour, maybe grandma, parents. We really, again, need to vet our clients as far as how they retrieve that email. Because, maybe they retrieve the email from the person who received that email, and that's okay. That you can certainly use the email in that context. However, again, it's back to woodshedding your client and figuring out how they retrieved these emails. And a tip here would be, make sure you ask the questions, gather the information first before you get into the specific pitfalls. Because if you give them the pitfalls first, they're probably going to try to wiggle around it and not tell you everything. So make sure you find that information out first and then give them the specific pitfalls as to, well, we're not going to be able to use it because of XYZ, because of the wiretap, because of the Stored Communications Act, personal, civil, and criminal liabilities. Now, as far as the criminal liabilities, and again, back to our own personal liability, what we're looking at is, for criminal liabilities, a violation of the Federal Wiretap Act would include a fine or imprisonment up to 5 years or both. So it's not worth it to use some really juicy piece of email. It's just not worth getting into that, getting yourself into trouble. As far as the civil liabilities, civil remedies would include injunctions, damages, punitive damages, reasonable attorney fees, and costs. Now, the damages, courts would assess the greater of actual damages, statutory damages of $100 a day for each day of the violation, or $10,000. Now, the $10,000 of damages, at least from the Eighth Circuit and what would apply in Missouri, is discretionary. So it's not statutorily awarded $10,000, but it is to the court's discretion. So with these sort of damages and the ability to collect on attorney's fees, that's fair warning that these actions may arise moving forward. The more that we get into these sorts of technical issues and the more of the technological advances. Now, keep in mind that the Federal Wiretap Act and Missouri Wiretap Act have strict exclusionary rules for oral and wire communications, not text messages and emails, so not electronic communication. So those are not strictly inadmissible. However, again, with the criminal and civil liabilities, it's not even worth getting into that and arguing the point that it's not strictly inadmissible, and so therefore it is admissible. You just don't want to risk yourselves and your license. And there's a 2-year statute of limitations. There's no need to have actual knowledge of the illegality. It's just the reasonable opportunity to discover it. We've talked about the pitfalls. And then, of course, keeping information out at trial, much like I indicated earlier, your objections, your lack of foundation, your lack of authentication. Make the opposing side do the work. Don't just let them walk through and admit a piece of evidence. You can score. You can keep it out if you make them do the work, make them lay the foundation. And some judges will strictly hold the attorneys to laying the proper foundation. So don't just take for granted that this piece of evidence may end up coming in. Make them do the work. Object. Make them lay the foundation. Make them prove the authentication. Additionally, hearsay. With emails, those are still considered hearsay. Now, if they're parties, it's probably going to be party admission, and so therefore admissible. But again, don't just take it for granted. Make the opposing side do the work, because you may catch somebody who doesn't know that argument. And so therefore, you score your point, and you keep that email out, or emails out. Again, something that wasn't exchanged through discovery, that wasn't turned over but was properly requested. Again, keep that in mind. But that comes with proper preparation before going into trial.
All right, we're going to go into the easy stuff in non-hacked emails. So how do you admit emails into evidence? Well, it's a good thing that these have been around for a lot longer than what we were talking about earlier, because if you think about it, emails are just correspondence, which are just letters, which are just like snail mail. So there's plenty of law out there to get emails into the record, and there's plenty of case law and statutes in order to get these documents in. So the very first thing that you want to do is make sure that you authenticate the document. You have to have a prima facie showing that it is what the witness claims that it is. Can a jury or the trier of fact be reasonably convinced that the evidence is what the proponent claims it to be? And how do you do that? Well, email authentication has been determined as appearance, content, substance, and other distinctive characteristics taken in conjunction with the circumstances to support a finding that the document is what the proponent claims. So there's a lot going on there. And how you work this is, and it's my favorite, distinctive characteristics. Usually, emails will have specific information. Oops, let me go back. Specific information, like the email address. If your email address, like mine, is mcruz@cordelllaw.com, well, there's only one M. Cruz, and you know where I work at Cordell. In the body of the email, I also have our logo. You can authenticate it based on the employment of the individual. Some people are really special now, and they like to put little sayings, like Gandhi or something, and if that is something that is specific to them and they have a story, you get that story out. Yeah, my wife loves the story about butterflies, I don't know, and that's a little saying that always pops up on her email account every time. If she's gonna send an email, bring it, or reply to an email, it's there. You know who it is. You can also authenticate it based on the circumstances. So start slowly. Get your evidence out. Ask your questions about a circumstance or an event or a person or a child. On such and such date, didn't you talk about, or didn't your client have an earache? And when he had that earache, he went to the doctor. And your doctor's name is so-and-so. Get all that information out and then get to the email. Do you recall an email that you sent to your wife saying there was nothing wrong with him? And then you start laying the foundation on that email to really hit on the other side. So tell the backstory. The most frequent ways to authenticate emails include these. People with knowledge of the events, which are usually the person who you're using to authenticate it in the first place, and you're laying the foundation. This next one, expert testimony or comparison with authenticated exemplar, is harder. There's no reason why you need to go down this road, because it's so much easier to get those distinctive characteristics out there, previous emails, this is just getting an expert to provide that testimony. I don't think it's worth it. This is the next one, the distinctive characteristics, including circumstantial evidence. So all of the stuff that surrounds the email, all of the events, all the people that they're talking about, all of those things are the way that you can authenticate and say this is a true email between these two individuals. The trade inscriptions is what I was telling you about earlier, those sayings at the bottom of your email, your employer's icon, whatever it is, that's down at the bottom, that will assist in it. And obviously, certified copies of business records are going to get the emails in, especially when it comes from the employer. Now, here's a really old, archaic rule, the reply letter doctrine. So this actually is so old that it's from like the 1800s or early 1900s. It's old. But if it's a letter that's received in the due course of the email, purportedly in answer to another letter, it's prima facie showing that it's admissible without any further proof of its authenticity. So you get that first email in, you get it by your distinctive characteristics, and then all the replies after that are automatically in. So you can get the whole email string in once you get that very first one in. Make sense?
All right, now we're going to talk about Facebook posts and information. Comes up all the time in family law and pretty much a lot of other contexts. But firstly, we have to keep in mind, okay, how do we retrieve this stuff? Is it public? Is it just available to anybody? You as an attorney, you can just figure it out yourself and look into it, see if it is public, or figure it out if it's in private settings. But a lot of times, you'd be surprised. You can just gather this information yourself because they don't keep it private. The opposing side, the opposing spouse, may just keep their Facebook open to the public. Additionally, how do we retrieve it? It can be through your client. Maybe they still remain friends on Facebook. They haven't blocked the other person out, and so the client may have access to it. So you're able to retrieve Facebook information through your client, or maybe a friend of a friend. If a lot of times spouses have mutual friends, and so they may not The opposing side may not think about that and blocking every one of those mutual friends out. So if you have somebody that may be on your side, see if they can access some useful Facebook posts or messages or photos. Additionally, through the process of discovery. Now, you don't want to catch objections to overly broad and not specific enough. You don't just want to say, give me everything on your Facebook, every single message, every single post, every single photo. You want to make sure you tailor your discovery request to what it is you're specifically looking for. If there are accusations of adultery, accusations of drug use, alcohol abuse, child abuse, anything like that, you want to specifically tailor your discovery request so that you're not dealing with it in court. You will lose credibility if you just have a sweeping, broad request, give me everything on your Facebook, give me unfettered access to your Facebook. If you go into court and you're disputing whether you should have access to that Facebook or not, you will avoid that argument or dealing with that early if you just specifically tailor your discovery request to what it is you're looking for. I've received discovery requests just requesting the password and username and access to everything. Well, it's not. It's overly broad. It's irrelevant. And so you just want to make sure that you tailor your discovery request to what it is you're looking for. You can also try to retrieve this information by subpoenaing Facebook. Good luck. Your case will probably be done before you even get a response. If anybody's had success doing that, then great, you're one of the lucky ones. But that is an option if you can't otherwise gather this information. But in all likelihood, the other options are going to be useful before having to rely on sending a subpoena to Facebook. Now, using this information at trial. Don't do that. But it is useful to, if you gather these photos, much like this, and that's the opposing side, and there's alcohol abuse accusations or child neglect accusations, use the photo. Again, we walked through laying the foundation, and it doesn't have to be the party itself. If you're, or the opposing party itself, as far as who's in the photo, if your client remembers that scene or has seen this photo before, you can prove up that photo through your own client. And that way, the opposing side doesn't try to minimize that photo. You can actually get it in through your client, and it'll have a much stronger impact through their testimony. But again, they don't have to be the ones taking the photo. They don't have to be the ones in the photo. You can prove up and lay the proper foundation by just something that they have seen before. They recognize it. It's a true and accurate copy. And identify that it's from Facebook. Identify when it was that they accessed this website, this photo. And make sure you move to enter it into evidence so that you can actually talk about the photo and use the photo. Now, on Facebook, we have comments from a lot of different people, in all likelihood, below a photo. And so what do we do with those? In all likelihood, you may catch a hearsay objection regarding all the comments below. But it's not hearsay. An argument against that, it's not hearsay if you're not offering it for the truth of the matter asserted. Make that argument. You don't care what those other people are saying in the comments. What you care about is the photo. So make the argument that it's not being offered for the truth of the matter asserted, so it's not hearsay. Now, the judge may overrule the objection or still sustain it. So what I like to do is have a redacted copy ready. In the event that the judge decides to sustain the objection to hearsay, make sure you have a redacted copy with those potential hearsay statements redacted.
So my question as the judge is, comments are not being offered for the truth. Why are they being offered?
Well, in all likelihood with Facebook, they're attached to the photo. And so the photo has these comments underneath it. And if you're not able to just extract the photo itself, and you're just able to take the photo with the comments, that's usually how Facebook, the actual website, prints it out. But you can certainly extract it. You can redact it otherwise, so that you can. But again, it's all about preparation ahead of time.
Can I just interject real quick? Ones that I've used before are excited utterance, then existing mental, emotional state. So sometimes there'll be like a curse word with an exclamation point, or I can't believe you did that, exclamation point. That's an excited utterance. Or then an existing emotional state, the SMH, shaking my head, or I'm so disappointed in you, how could you do that? Those are then an existing emotional state, so you might be able to get them in through not, it's hearsay, but there's an exception to the hearsay rule.
What about a comment like this underneath? If there's, let's say there's a comment from a friend, non-party, that says, you were wasted for days, and that plays into your argument, and the opposing party who's pictured in the photo didn't make a comment, you can make the argument that it's an admission, a party admission. They didn't deny it. They didn't deny that they weren't wasted for days. So that's another way to say, hey, it's a party admission by not commenting. It's worked before. Will it work 100% of the time? Maybe not. It just depends on what judge, what jurisdiction, what the judge wants to do in that particular situation. But these are tips. These are arguments to make in the event they become an issue. But again, usually having a redacted copy ready, if the judge is just not budging, will help you get that photo in anyway. And in addition, if you have that extra copy for the judge beforehand, the judge has already looked at it and has that information anyway. Judges are people just like us, and so whether it's admitted or not, they already have that information, and they're going to remember that nonetheless. Medical records. Now, we first have to certainly consider HIPAA considerations in retrieving our medical records that may be useful in and in most cases, it's in our child custody cases. Sometimes if you have spousal abuse cases, medical records and their mental health may play into that as well. But you first have to make sure that you send out your HIPAA authorizations through, and I usually do that in conjunction with my discovery requests. I send over copies of HIPAA authorizations attached to the discovery requests and request that they fill them out and return them so that we can request those medical records. Now, the reason we want to keep HIPAA in mind is because there are tiered civil penalties to consider if we access these medical records without an authorization. And so the penalties range. So for instance, it ranges in minimum versus maximum penalty, and it ranges in your how you retrieve them. So if the individual didn't know and by exercising reasonable diligence would not have known, he or she violated HIPAA, the minimum penalty would be $100 per violation, with an annual maximum of $25,000 for repeat violations. Now, the Department of Health and Human Services is still prohibited from imposing civil penalties if the violation is corrected within 30 days. So you do have a grace period. Again, it's not worth it. Just send out your authorizations and you'll be okay. Maximum penalty for that particular situation for an individual who didn't know would be $50,000 per violation with an annual maximum of $1.5 million. It's just not worth it. Just send the subpoenas, send the authorizations, and make sure that you have that specific request or that specific authorization. There's also minimum and maximum penalties for violation didn't have willful neglect. or due to willful neglect. So there's different tiers. I mean, you're talking $1,000 per violation minimum, annual maximum of $100,000 for repeat violations, and so on and so forth. Again, you can look them up yourself. You shouldn't have to worry about it if you send out your HIPAA authorizations through your discovery requests. Now, why do we need the medical records to begin with? Best interest of the child is something to consider. The mental health of the respective spouses plays into what's best for the child. Now, we have been limited, however, through objections of physician-patient privilege. If the case itself doesn't have anything to do with child abuse or child neglect, that physician-patient privilege will overcome those medical records requests. But child abuse and neglect, it's pretty loose. So you can really play into that neglect if we hear a lot, oh, he or she is bipolar. Well, if there are facts that support those sort of mental health issues, you can really make the argument that the exception, best interest of the child, would overcome that physician-patient privilege. Additionally, if you retrieve those medical records, hearsay, there's a lot of hearsay in there. You have nurses who may have comments in there. Perhaps there's comments from the doctor. There's comments from the patient, him or herself, the patient's family. So there may be hearsay that you certainly have to get around. However, you can get it all admissible through business records. The rules of evidence allow business records, affidavits, or the custodian of records to prove up those medical records to have them entered into evidence. And so Section 490.680 allows you to get those records admitted without the custodian of records having to appear in court. Now, you must first have certified copies of those business records to be admitted at trial. If all parties are served with those records ahead of time and the certifying affidavit with those records attached has been filed at least 7 days before trial. So you need to make sure that you abide by those two principles. However, let's say you didn't have a chance to disclose that information at least 7 days before trial. You should have, but let's say you didn't. Section 490.692 allows you to, or actually, that was 490.692. Section 490.680 allows you to get those records admitted with the custodian of records present and proving up that those records were kept in the regular course of business, that at or near the time of the act, condition, or event, and identifies the mode of of the preparation.
All right, so let's move on to expert testimony. Your Section 490.065 governs the admission of expert testimony. It is up to the trial court's discretion to admit or exclude expert testimony, and they're given a wide amount of discretion on the weight of the testimony that is going to be provided. Your common experts in family law cases can include mental health practitioners, psychologists, counselors, social workers, school counselors, pediatricians, and other medical specialists who've treated the child. But remember that a party can also qualify as an expert and give testimony based on his or her behalf. Some of those things can include children's reactions to events, how the children are affected by the events, medical issues that were seen but not treated by a physician, and then how that parent treated those issues, educational decisions that were made. Sometimes they go hand in hand as far as your psychological issues along with your educational issues, developmental issues. So you have to ask, are the facts and data presented by the expert a type that is reasonably relied upon by experts in that field, or is the methodology reasonably reliable? If those answers are no, then you cannot provide the testimony to the court. Expert testimony means that the facts or the data that were perceived by the expert and made known to the expert and known prior to the hearing, then those facts are reliable. But an opinion by an expert cannot be based just on speculation or conjecture. There can't be might haves, could haves. Those are devoid of any evidentiary value. We're about to go to lunch. So, an opinion can only be given if it's not common knowledge that it invades the province of the jury. So it can't be something that everybody knows. It has to give facts from the expert's own knowledge and observation, or hypothetical facts, or two of those combined. If the expert has personal knowledge, then a hypothetical is not necessary in order to get the expert testimony in. The question of whether an expert's opinion is based on sufficient facts and supported by substantial evidence is a question of law. So you have to present that to the court, get a ruling on that. Typically, it's under voir dire, outside of the presence of the jury if you have a jury. And it's at the trial court's complete discretion whether to admit or exclude the expert's testimony. The expert can provide opinions based on statements of third parties which are typically deemed hearsay. So normally, hearsay is not allowed, except when the hearsay includes results in medical literature, information learned in a professional seminar or courses of study. These would normally be inadmissible hearsay, but in this situation, experts are allowed to provide that testimony anyway. As long as the source serves as the background for the expert's opinion and are not offered as independent substantive evidence, then the testimony can be entered. Experts can be cross-examined about facts not in evidence to test the validity of their opinion. So wide latitude is given to test the expert's factual basis for the opinion. So where the psychologist's opinion of a mental illness is before the court, an expert may testify to the knowledge of facts surrounding the party's mental status, including the past interactions that bear on that opinion. So make sure that you have your witnesses vetted. If it's the other side and you're doing the cross-examination, ensure that you can considerably cross-examine those witnesses based on the facts and the opinions that they've provided. You're going to want to maybe take a deposition ahead of time, know what that expert is going to say, and then at trial, for trial purposes, ensure that your cross-examination will pull out all of the holes that they have in their opinion.